repeated references to the machete, correct?
That's correct. And we'll go back.
And so we're not here on that.
Correct.
You're attempting to gain an added victory by securing effectively an acquittal by a no sufficient evidence finding, right? In other words, your client couldn't be retried if you prevail.
Right. That's correct. I don't think that Kongkeo should be tried on this aggravated assault conviction because the state completely abandoned its charge theory.
Well, but we're here on a sufficiency of the evidence review, right?
Right.
And it's true, I think, and you just said this, that the jury instructions matched the charge.
Right.
And there was evidence of the use of a hammer and a stick, correct? Regardless of what the prosecutor said or the theory they elected to pursue. The evidence was that your client at least attempted to strike the victim in the head with a hammer, right?
I'm going to push back on that because I think, no, I believe that the victim testified he never even saw the hammer. And the victim never testified he was in fear or apprehension based on the wind stick or the hammer, which I think is where the majority of the Court of Appeals strayed. Again, there's no testimony from the victim that he was in fear or apprehension of either of these items. Again, there is testimony they didn't even know about the hammer. And so then we have the majority saying, cobbling together all of this circumstantial evidence, and then I believe making a factual determination that the hammer in this case is a deadly weapon. And I just don't think that that is fundamentally fair to Kongkeo. Again, you've given the state 2 bites at the apple. It gets to charge one offense, try another offense, and then when it had abandoned its charged offense and doesn't show up on appeal, and the majority is going to say, all right, but based on all this circumstantial evidence, I think we can cobble together.
At a minimum, would you agree, could we all agree, that based on the way the jury was instructed and based on the verdict, that at least the jury concluded that the hammer/stick was a deadly weapon and also concluded that the elements of ag assault had been met?
I'm going to push back again because I think no, because I raised instructional errors on the deadly weapon, which the Court of Appeals didn't make a ruling on because it has to go back for a new trial on the jury trial instruction, but did suggest to the district court that if it retried this case, it needed to better define the jury instructions because the jury in this case was never instructed on deadly weapon. The jury instruction literally just was Kongkeo did this assault with a hammer and or wooden stick. It never defined it, like it.
Okay, but
so no, I don't think
that you've got jury instruction potential claims also. I'm just trying to square away what we can conclude on a review. The jury thought it was due, and it seems to me that even if it was error, even if they were poorly instructed, they thought they were convicting your client of ag assault for the use of a hammer and a stick. That's what the jury thought.
Sure, but that wouldn't meet the elemental definitions of aggravated assault because it doesn't define deadly weapon.
Okay.
So I think that that's where I can't agree. And again, I just think it deprives Kongkeo of its what is Kongkeo supposed to do at a jury trial? If he's been charged with a hammer or wooden stick, but then the prosecutor makes an election that it's a machete. So now he's defending against a machete. And by the time we get to closing arguments, the state has just completely abandoned the aggravated assault claim. I mean, it's full steam ahead on its attempted murder claim because it didn't get machete as the deadly weapon in the jury instruction conference. And so Kongkeo, again, only focuses his closing arguments primarily on the attempted murder charge. I just don't think it is fair to a defendant that the state gets to charge one offense, try another offense, and then hope an appellate court will save the charged offense. I don't think that's fundamentally fair to criminal defendants. When they are put on notice about what they're supposed to defend against, the state then gets to change what it's alleging against the defendant, and then on appeal it can be saved. I don't know how that's fundamentally fair to criminal defendants in the state of Kansas. Particularly, which I think this sort of dovetails nicely into the second issue, the majority worked very hard to scour this record to come up with some evidence that it could sustain a aggravated criminal assault conviction against Kongkeo. The jury instruction issue here is a requested voluntary intoxication instruction. So it's preserved for appellate review, and because Kongkeo requested it, the evidence on appeal is viewed in the light most favorable to him. So it is a sufficiency analysis, but in his favor. And here, instead of cobbling together all the circumstantial evidence that would support Kongkeo, the majority went out of its way to nitpick the evidence to suggest that there is some evidence that he was not impaired. But appellate court's job is to not reweigh evidence. It is not to do the state's job for it. And so why is it when the sufficiency analysis runs to the state, a conviction is affirmed, but when the sufficiency analysis runs to Kongkeo, he doesn't get that benefit? I just don't think that you can have it both ways in this case.
Can the appellate court, what you're saying is nitpicking is reweighing, but from another perspective, could it be viewed as an analysis as to why the inferences being drawn are not reasonable? And if so, I mean, that would seem to fit with an appropriate factual appropriateness inquiry for a jury instruction.
I don't think so when you have to look at the evidence in the light most favorable to the requesting party, and you have no state's brief to push back against that. I don't think that it is proper for the appellate court to then do the state's job for it to present evidence that might weigh against my client. But my client, he didn't testify. The evidence at trial was that he was intoxicated. He smelled like beer. When he was arrested, he had a beer can on him. He had been drinking all day. He was making nonsensical allegations and remarks. He couldn't keep a grip on anything in his hands.
But what evidence was there? I mean, I know that the evidence showed that there was alcohol consumption, but that's not our test. Our test is not whether the defendant was intoxicated. It has to be to the degree that his ability to form intent was impaired. And here, didn't the district court make findings that there was not a loss of reasoning, planning, or motor skills, that his actions, such as fleeing police and responding to warnings, demonstrated that he was aware and in control, and that, you know, even though he was drinking, it did rise to the level of not being able to form this specific intent?
I will agree that the district court made those findings. I think that that was erroneous. And again, I think that we put forth, because we put forth in our brief that he was impaired to the extent that it impacted his reasoning. And again,
And what evidence did you put forth?
Again, the fact that he could not keep his grip on anything in his hands, and that he wasn't reasoning at all. Again, he was alleging that the victim had poisoned his clothes, had put olive oil in his clothes, was demanding that the victim come back in the house and see why had he poisoned his clothes. And so I think we have evidence of impairment, the fact that he wasn't making any logical allegations.
But why is
and
that
he was
impairment? You know, why was there a link between the alcohol and the impairment there? Because, you know, usually when you're impaired, I mean, well, I guess I won't say that, but was there a link?
I think that there is a link, right? I think he is drunk. He is making nonsensical allegations against his friend / landlord. And he gets mad because his landlord won't come into the house with him and see what is going on with his clothes that have allegedly been poisoned. And then he gets demon angry and starts swinging at his landlord, but again, cannot keep a grip on anything. He's so impaired that he's just like, everything is falling out of his hands. He just appears to have a hammer in his pocket. It's not like he's intentionally like going out of his way to find weapons or things. He just has these on him. And again, we have a dissent here that would have said, in the light most favorable to Kongkeo, they would have no problem finding that a voluntary intoxication instruction was factually appropriate. Because again, it's in the light most favorable to Kongkeo. And I think here we have evidence of both intoxication and impairment. And again, I think that it is sort of a sufficiency analysis, and it would seem obvious to Kongkeo that when the sufficiency analysis ran in the state's favor, the majority was willing to find that for the state. And it doesn't seem fair that they're not willing to put in that for Kongkeo. And I do think they reweighed the evidence. And again, one of the things they said was that a law enforcement officer testified that he wasn't slurring his speech. A law enforcement officer just testified he couldn't recall. And again, further, which I think goes to some of this stuff that happened in the district court too, Almost no one involved in this trial spoke English. Kongkeo's primary language is not English, it is Laos. He needed a Laotian interpreter for all the proceedings. The victim's primary language is not English, it is Spanish. He needed an interpreter for the trial proceedings as well. And so to say that, I mean, he walked away from police sirens, I guess. I think a lot of impaired people would walk away from police sirens. I don't think a law enforcement officer could testify whether or not Kongkeo was slurring his words. He doesn't speak English. He was never interrogated. I think he might have said a curse word at the cop as he was like walking away from the altercation. But I think in the light most favorable to Kongkeo, he put on evidence of intoxication and impairment. And the state presented no brief. And so it was further error for the Court of Appeals to hold that that was somehow harmless and that Kongkeo wasn't prejudiced by getting that defense instruction.
But what wasn't their primary holding that it was not factually appropriate?
The district courts or the Court of
The
Appeals?
Court of Appeals.
The Court of Appeals found that it wasn't factually appropriate.
So the fact that they went on to talk about harmlessness
Yeah, it's further error.
maybe doesn't matter, right?
Gosh, I guess.
Okay.
But it would just seem that if you don't have a state's brief, then why would you go out of your way to say, oh, we don't find it factually appropriate? But if it were, there's no prejudice, as if that's not a burden that a party bears, a party that didn't show up. So I just don't think it's fair to Kongkeo, the work that the majority did to save the aggravated assault conviction, but deny him his requested defense instruction. They went to the heart of his defense.
Well, they didn't save the ag assault conviction. I mean, they reversed it, right?
Yeah, to be retried. I mean, on sufficiency, you can't be retried.
They didn't save it.
Again, because the state didn't show up, so the state couldn't bear its burden on prosecutorial error. If this court doesn't have any further questions, then I would just say the state has failed to participate in this appeal, and the Court of Appeals erroneously did the state job for it. This court should reverse on sufficiency for the aggravated assault and remand for a new trial on the attempted murder.
Any questions, colleagues? Thank you very much for your arguments. That concludes this morning's docket. Court will be in recess until tomorrow morning at 9 a.m.